hearings apply.
Good morning. I'll take the appearances for the individual defendants.
Good morning, Your Honor. Jennifer Yee and Jacob Valdez from Snell and Wilmer on behalf of the individual defendants, Casey Rana, Dylan Rana, and Brenda Feeney.
Good morning. And I'll take the appearance for the entity defendants.
Morning, Your Honor. Tyler Bowman from Wallen and Hester on behalf of Trinity Trust, LLC and Trinity Lumber, LLC.
Good morning. This is the time set for our Rule 16 scheduling conference. I have reviewed the joint report and the proposed scheduling order. So let me first ask, on the initial disclosures, the proposed order had a date of July 7, 2026 for making those disclosures. Has that been done, or does that date need to be adjusted?
Those have been completed, Your Honor.
Okay, great. And other than that, do the dates set out in the proposed scheduling order still work for the plaintiff?
Yes, Your Honor.
And what about for the individual defendants?
Yes, Your Honor.
And for the entity defendants?
Yes, Your Honor.
Okay, so we'll go ahead and adopt that schedule based on the dispositive motion deadline of May 28, 2027. We're looking at setting the 15-minute virtual trial setting conference on June 17, 2027 at 9:30 a.m. Does that work for you, Ms. Pasqualoni?
Yes, Your Honor, that should work for me. Thank you.
Okay, Ms. Yee
Yes, Your Honor.
and Mr. Bowman.
Yes, Your Honor.
Okay, great. We'll include that in the scheduling order, and I'll sign off on that, and you'll get a copy of that. I did note that in the joint report, there seems to be disagreement about whether a privilege log should be required for communications between the parties and their counsel of record in this case, predating the filing of the complaint. Has that been resolved, or do you need some, is that something we need to discuss today? Ms. Pasqualoni?
Yes, Your Honor, that was a point of minor dispute. The parties have reached an agreement on an ESI protocol with the exception of that issue. The parties have agreed that a privilege log is not required for communications that occur after May 6th, which is the date of the complaint was filed in this case. But plaintiff has requested that the date apply from when counsel was retained by the parties in connection with the case, which on the plaintiff's side, that would be about a week or so before the complaint was filed. Our position with respect to that is that there were voluminous communications between counsel of record and the client pre-filing of the complaint. And in our experience, the parties are typically agreeable to not require the parties to have to prepare a privilege log with respect to communications between counsel of record and the client that are post-retention in connection with the case. And the defendant's position, I believe, is that that should only apply after the filing of the complaint.
Okay, let me start with the individual defendants. Ms. Yee?
Thank you, Your Honor. Rule 26B6A requires parties, when they withhold or redact a document or ESI based on a claim of privilege or work product, to provide a privilege log with enough information to give the other side a reasonable basis to evaluate the claim of privilege or work product protection. And that is required only in the instance of when such ESI or document or information is responsive to a written discovery request. And in this case, the individual defendants have served written discovery requests on the plaintiffs back in July, which the responses are due later this month. Our position is, if there is a responsive document or communication that is being withheld on privilege grounds, then we need to see a privilege log so that we can assess whether or not the claim of privilege or work product protection is proper. For example, if there's the inclusion of a third party who is not the client or not the attorney, on a communication, that would waive the privilege with respect to that particular communication. And without a log, we cannot evaluate whether or not that was done. And so while we are amenable to not requiring a log for communications or documents withheld that are post the date of filing the complaint, for the week or so before the complaint was filed, if the communication or document withheld is responsive to a specific discovery request that we issued, we would exercise our rights under Rule 26 to see the log and make that determination for ourselves.
Okay, Mr. Bowman, do you have a position on this?
We are amenable to the Jennifer MSE's position as she stated.
Okay. I mean, here's the issue. I'll tell you, when I was in private practice, I think it was pretty routine that we didn't prepare privilege logs for that period post-retention for the specific matter. But I mean, Ms. G is correct as to what the rule says. And so if they want to insist on that, it's not something that I recall seeing often, if ever, when I was in private practice. But if that's the position that the defendants are going to take, then it's going to apply to everybody that way. So Ms. Pasqualoni, for that week and a half period, it sounds like you'll need to prepare a privilege log.
Thank you, Your Honor. Yes, that's been my experience as well. I've never had a case where this was insisted upon, but if that's the defendant's position, we're happy to comply with that.
Okay. Are there other issues that we ought to be discussing this morning from the plaintiff's perspective?
The only other issue, Your Honor, that I wanted to raise is the parties have not reached an agreement on a protective order. In this case, at this time, we do believe a protective order will be warranted here, given this is a case concerning allegations of misappropriation of confidential information and trade secret information. The plaintiff has prepared a draft protective order. We have not circulated it to the defendant's counsel yet, but that should be forthcoming.
Okay. I will anticipate receiving a hopefully stipulated form of a protective order, and I'll review that and if appropriate, enter it. If there's disagreement, then obviously somebody's going to have to file a motion to bring the issue before the court, but hopefully there'll be a stipulation on that. Anything else from the plaintiff?
No, Your Honor. Thank you.
Anything further from the individual defendants?
Yes, Your Honor, there is an issue we wanted to raise regarding the stipulated preliminary injunction that was entered on May 21st regarding the return or destruction of what the parties have called the restricted files in this case. That injunction was entered at the end of May. The individual defendants' devices that have those restricted files have been sequestered using the services of a third-party e-discovery vendor since May. And we're now at the point where, per paragraph 10 of the preliminary injunction, the plaintiff needs to let us know whether or not they are requesting the return or deletion of those files that are in dispute in this case. We have asked several times for direction in that regard, and plaintiff has indicated that they're going to request the return of those files, but they need input from their expert regarding how they want those files returned. And we followed up several times over the last several months and haven't gotten an answer on that. So we would respectfully request that a reasonable time limit be imposed so that the parties can move on, our clients can get their devices back, and these files can be apparently returned, which is the plaintiff's desire. But we need to get that process moving in a reasonable time frame.
Okay, Ms. Pasqualoni?
Yes, Your Honor. There has been some back and forth on that. We have not received any sort of request from defendants for a deadline to respond. We're dealing with a forensic expert who's been on vacation, and we didn't see any urgency with respect to the matter, given we are comfortable that the information has been requested, but certainly, if defendants had requested a deadline, we would have worked with them to comply with that. But we are comfortable agreeing, within the next couple of weeks in providing more further direction on how exactly the items should be returned.
When does your vacationing expert return?
We just received guidance yesterday, Your Honor. So I think we should be able to come to resolution relatively quickly. We also have our clients have been out as well on vacation. So it's been a lot of, back and forth with schedules.
Okay, I certainly can understand the individual defendants wanting to get their devices back. And so I think it's reasonable to put a deadline on that. Ms. Pasqualoni was asking for 2 weeks. Is that reasonable in your mind, or do you think it needs to be shorter than that?
2 weeks is fine. Thank you, Your Honor.
Okay, so that would be, looks like, if my math is right, August 21. Okay, are there other issues, Mr. Bowman, that the entity defendants wish to raise?
Not at this time, Your Honor.
Okay. Thank you all for appearing. I would tell you, if you haven't done so already, I know some of you have been before me before, but if you, especially if you haven't, take a look at the procedures and protocols on the Superior Court website, on my division's page on the website. You'll find information that will be helpful to you. And with that, I'll just say have a good weekend, everybody, and thank you for appearing.
Thank you, Judge.
Thank you.